You open your mailbox and find a letter from your landlord. Your rent is going up, by a lot, and they've given you almost no warning. Your stomach drops. Can they actually do this? Is there any limit on how much they can raise your rent? And how much notice are they legally required to give you? The answers depend entirely on where you live, and some of them will genuinely surprise you. This is what the law actually says about rent increases in the United States. Welcome back to Plain Verdict. Let's get into it. Rent increases are one of the most searched legal topics in the United States right now, and for good reason. Rents have increased dramatically across the country in recent years, and millions of tenants are asking the same question: is what my landlord is doing actually legal? Today we're breaking down exactly what the law says about rent increases, how much notice landlords must give, whether there are limits on how much they can raise your rent, and what you can actually do if you think an increase is unlawful. Let's start with the uncomfortable federal reality. There is no federal rent control law in the United States. Congress has never passed legislation limiting how much landlords can charge or how much they can increase rent. At the federal level, your landlord can theoretically raise your rent by any amount they choose, as long as they follow proper notice procedures, and your lease allows it. This means your protections against rent increases depend entirely on your state, and in many cases, your specific city or county. The United States is essentially a patchwork of different rules. Some states offer strong tenant protections, others offer almost none. Knowing which category your state falls into is the most important first step. Even without rent control laws, most states require landlords to give proper written notice before raising rent. And the type of tenancy you have matters enormously. If you have a fixed-term lease, a lease with a specific end date like a one-year lease, your landlord generally cannot raise your rent during that lease term. The rent is locked in for the duration of the agreement. Your landlord must wait until the lease expires before implementing any increase. If you have a month-to-month tenancy, the rules are different. Most states require landlords to give between 30 and 60 days written notice before a rent increase takes effect on a month-to-month tenancy. Some states require more. California, for example, requires 30 days notice for increases under 10% and 90 days notice for increases over 10%. New York requires 30 days notice for increases on month-to-month tenancies. Texas requires only 30 days notice with no distinction based on the size of the increase. The notice must be in writing in almost every state. A verbal heads up from your landlord is not legally sufficient. Now let's talk about the states and cities where real limits on rent increases exist. Rent control and rent stabilization are two related but distinct concepts worth understanding. Rent control typically refers to hard caps on the maximum rent a landlord can charge, often found in older housing stock in cities like New York and San Francisco. Rent stabilization is more common and refers to laws that limit how much a landlord can increase rent each year, typically tying permitted increases to inflation or a fixed annual percentage. California passed a statewide rent control law in 2019, AB 1482, which limits annual rent increases to 5% plus local inflation or 10%, whichever is lower, for covered properties. Oregon was the first state to pass statewide rent control in 2019, limiting increases to 7% plus inflation annually. New York has strong rent stabilization laws covering millions of apartments, particularly in New York City. New Jersey has rent control ordinances in many municipalities. Washington, D.C. has strict rent control covering most rental units built before 1976. However, and this is critical, these protections don't cover every rental unit even in these states. New construction, single-family homes, and luxury units are often exempt. Knowing whether your specific unit is covered requires checking your local laws carefully. On the other end of the spectrum, many states offer little or no protection against rent increases beyond basic notice requirements. Texas, Florida, Georgia, Arizona, and many others have no statewide rent control, and in fact, many of these states have preemption laws, meaning they have actively prohibited cities and counties from creating their own rent control ordinances. If you live in one of these states, your landlord can raise your rent by essentially any amount as long as they give proper notice and your lease allows it. In these states, your lease agreement becomes your primary protection. A fixed-term lease locks in your rent for the lease period. A month-to-month tenancy gives your landlord significant flexibility to increase rent with relatively short notice. If you're in a low protection state and facing a large rent increase, your most practical options are negotiating directly with your landlord, deciding whether to renew your lease or find alternative housing, or advocating through local tenant organizations for stronger protections in your area. Even in states with limited rent control protections, there are specific circumstances where a rent increase is illegal, regardless of where you live. Mid-lease increases. If you have a fixed-term lease, your landlord cannot raise your rent before it expires. Any attempt to do so is a breach of your lease agreement. Insufficient notice. If your landlord raises rent without giving the legally required written notice period, The increase may be unenforceable until proper notice is given. Retaliatory increases. If your landlord raises your rent shortly after you complained about conditions, reported a housing code violation, or exercised any legal right, this may constitute illegal retaliation. Most states have anti-retaliation laws that specifically prohibit rent increases used as punishment for tenant advocacy. Discriminatory increases, raising rent specifically targeting tenants based on race, religion, national origin, family status, disability, or other protected characteristics, violates the Fair Housing Act, regardless of rent control status. If you believe your rent increase falls into any of these categories, document everything. Send written objection to your landlord and contact a tenant rights organization or legal aid society in your state immediately. So what do you actually do when you receive a rent increase notice? Step 1. Read your lease carefully. Does your lease have a fixed end date? If so, your landlord cannot raise rent until it expires. Does your lease contain any provisions about rent increases? Some leases specify permitted increase amounts or notice requirements. Step 2, check your state and local laws. Does your state have rent control or rent stabilization? Does your city have local ordinances that might apply? Is your specific unit covered by those protections? A quick search for your state or city's tenant rights laws will tell you. Step 3, verify the notice was legally sufficient. Was the notice in writing? Did you receive the legally required notice period? If the notice was deficient, the increase may not be legally enforceable yet. Step 4, if you believe the increase is illegal, send written objection to your landlord by certified mail, clearly stating why you believe the increase violates applicable law. This creates a paper trail and puts your landlord on notice that you know your rights. Step 5, contact a tenant rights organization. Most states have free tenant advocacy organizations that can advise you on whether your specific increase is legal and what options you have. Rent increases are one of the most stressful and disorienting things a tenant can experience, especially when they're large and feel unexpected. But the law gives you more protection than many tenants realize, particularly if you have a fixed-term lease, live in a rent-controlled area, or can demonstrate that the increase was retaliatory or discriminatory. Knowing your rights before you receive that notice is always better than scrambling to understand them after. If this video helped you subscribe to Plain Verdict, we break down a new legal concept every week in plain language. And if you're dealing with a rent increase right now, drop your state in the comments. We read every single one.